Hi Charlotte, I know this is a bit speculative, but it may well be that you have secured, indirectly at least, the future of investigative journalism in Australia. How does that feel?
I don't know about the extent of that being so, but I'm really proud of the judgment, and I'm really proud of all the work that went into the investigation and defending it.
Munjed Al Muderis was a high-profile surgeon with a glittering reputation who specialised in osseointegration, where implants fuse with amputees' bones, but he was not all that his positive PR suggested. How did you get onto that story?
So stories come from any number of places, sometimes a source, a document, a leak. In this particular story, this one came from a conversation with my father, who is an amputee and consulted with Dr Al Muderis in 2018. He didn't go ahead with the surgery, but was warned by people to not go there, essentially. The risks are very high, and he tends to downplay those, and there's this underclass of patients who have been really abandoned by him. So that kind of fleeting interaction always stuck in my mind as something to look into if I had the opportunity.
What stage did you approach the doctor?
He became aware that we were investigating, I would say about midway through, and he enlisted a PR firm to encourage his patients who had positive experiences to reach out to us. And he was calling some of our sources, trying to figure out who was speaking and what was being said. So he was aware that it was going on for a significant amount of time. Once we had filmed the interviews with patients and our independent expert, and we were clear on the allegations that we were going to publish, we invited him for an interview, and he said yes to that. I don't remember the date, but it was a couple of weeks before we published in the end, and it was a 2-hour television interview, so we had a very thorough experience of putting everything to him.
Yeah, I thought it was pretty fair, the program that ran and your reporting. I mean, you did give them a say. You did run those patient interviews. How important was it to get that balance?
Yes, this is something that came up in the trial, whether we were accused by his lawyers of only focusing on the negatives or overemphasizing the negatives and ignoring the positives. The judge ultimately found, and which was our view going into it, was that it wasn't strictly necessary to have this sort of balance in the way that he saw that we needed to, because there was a significant cohort of his patients who had severe complications and severe issues. So we did include, one patient who had a positive experience with him in the broadcast, and we did make reference to, the incredible work that he does and the benefits of osseointegration, but we didn't see the need to, make the show about the, huge amount of people who came forward and said they had positive experiences.
What were the main findings, just briefly, about his patient care?
So there were problems from really the very beginning to the very end of his dealings with patients. Everything from the types of patients he chose to operate on being inappropriate, in that they had comorbidities that made them high risk of failure for the surgery that he either downplayed or ignored, to on the operating theatre itself, he made mistakes that had devastating consequences for patients. And then in the aftercare side of his treatment of them, he either wasn't available to respond to their problems, or he actively ignored their pleas for help.
So in court, because he sued, so in court, you were cross-examined for 5 days by one of the country's top barristers, Sue Chrysanthu. I thought she was fairly critical, to say the least, of you. Some of the things she said were that you were unqualified to be an investigative journalist, you lacked expertise, your journalism was malignant, dishonest and malicious, that you had no concept of ethical practice, as journalists or even as human beings, which sounds a bit over the top. So how was that experience for you?
Yeah, it's not something that people want to do, any journalist wants to do, but by the end of it there was actually 6 days because we had the separate confidential source application. So it was a very long time, and while there was a lot of insults and sort of aggressive language and colourful kind of allegations thrown at me, I didn't feel that it was actually that difficult of an experience, the cross-examination, because the types of questions she was putting to me were so devoid from reality that it was easy to sort of knock them back. So yeah, I guess, you know, when you're telling the truth, it's quite easy to answer questions, and I didn't find it overall that challenging.
So legally, what were Nine's defences
to the overall case?
Yeah.
So our main defences were truth and public interest. We also had honest opinion, but that didn't end up being ruled on. So yeah, the truth was examining the evidence from patients, surgeons, experts, and then the public interest was examining evidence from the journalists.
And it was the first time that public interest defence had been used or was successful, is that right?
Yes, it'd been used once before, but this is the first successful application.
Okay. Was that the expectation? Because, you know, it's new, yet to be tested, and it came through?
Yeah, we felt from the beginning this was a very strong case for that defence because it's kind of unarguable that matters of public health are in the public interest. But what it did is it just opened up an enormous amount of scrutiny of the processes that me and the other two journalists went through.
So with the public interest defence successful this time, do you think that'll impact future cases?
I hope so. I hope that in an ideal world, it would be great to not have to put our sources through the experience of aggressive cross-examination that occurred in this case. I would much prefer for the journalists to be the ones who front the court and deal with the cross-examination and deal with the insults rather than, you know, the vulnerable people that trust us to tell their stories. So I hope it becomes a more kind of leading defence. I do think it will embolden investigative journalism a little bit more, and yeah, I guess we'll wait to see how it plays out.
I mean, if that's true and if that works out to be that way, it's a monumental contribution, Charlotte, really, and potentially for future cases. I note that he is appealing. What's happening there?
Yes, so he has appealed basically every single point in the judgment. He's also appealed parts of the Bromwich judgment, which was to do with the confidential sources. So it'll be a lengthy process. The good thing about it is that none of our witnesses have to be called again. No evidence has to be, new evidence has to be put on. It's really just legal arguments between lawyers that'll be heard sometime next year. And we feel like we've got a very strong case. The public interest defence is something that he could go after, seeing as that's a new law and there's not much, history behind that. But overall, I feel like we're in a good position.
Yeah. His legal costs are pretty steep, right?
Yes, the last estimate I had was that he had spent about $8 million and we had spent about $11 million. So it's nudging up to $20 million all up, which is
massive. Okay. Thanks, Charlotte. I really can't wait to see what you do next.
Thank you.
In my interview with Charlotte Grieve, she mentioned that the public interest defence to defamation was successful in her case. I wanted to find out more about this kind of defence and whether it may work in future cases. So I have with me Dean Levitan, a partner at Minter Ellison. How are you, Dean?
Good, Bill. Good to be with you. It's exciting to see the public interest defence succeed for the first time. We've all been holding out for it, and a victory is important for public interest journalism, so looking forward to talking about it.
Dean, could you give us some background on how this defence to defamation came to be?
Yeah, sure. So the defence really was designed by lawmakers to enable public interest journalism to be defended even where you can't prove the truth of allegations to a court standard. And so there really is a recognition by lawmakers that responsible public interest journalism, investigative journalism, should be protected.
Great. How does it work?
So really, if a plaintiff can prove that they have been defamed and that it's caused serious harm to their reputation, then a publisher can try and defend it on the basis of what is called this public interest defence. Now the defence has three elements. The first is that the matter that it relates to must be in the public interest. So that's not relating to private or personal matters, but things that concern public life and those who live within the public life. The second element is that the publisher, and that's all the publishers, so the corporate defendant, the corporate publisher, but also the journalists, the editors, everyone who's involved with the publication, must believe subjectively that publishing that was in the public interest. And the third element, and this is really the most contested element normally, is whether that belief that the publishers hold is objectively reasonable. So was the belief that it's in the public interest a reasonable belief? And that's really the ball game, if you can say it that way.
Wouldn't most journalists think that their stories are in the public interest anyway?
Absolutely, and that's why that second element, that subjective belief that the journalist might hold, is not usually a massive area of contest. But the caveat to that is there must be evidence that they believed it to be in the public interest. So they can't come to court, 12 months after publishing and try and sort of retrospectively piece together a belief. They need to be able to show that they did the work, that can evidence that at the time they held that belief as well. So what's relevant is that at the time of publishing it, at the time of investigating it, they held a belief that it was in the public interest.
What kind of evidence would the courts look at?
Well, firstly, they'll take evidence from the journalist. So the journalist must give evidence in order for a public interest defence to succeed, because they need to go into their subjective state of mind. They need to be able to credibly explain why they held the belief that it was in the public interest. So that's the first thing. And then the courts will look at any other sort of corroborative evidence. So did you send some emails at the time that gave insights into what your belief was? Did you speak to your editors and they might give evidence about that? What research did you do, and do you have documents to substantiate that? That will show that you did the work that corroborates your subjective belief in the public interest of the story.
So it sounds like it'd be good for investigative journalism.
It's great for investigative journalism. It is a massive step in the right direction. Under the previous Defamation Act, before these changes came into effect about 2 or 3 years ago, really it was truth or bust for public interest journalism. If you couldn't prove the allegations to the court's satisfaction, it was very hard to defend it. Now this case paves the way for the public interest defence to defend public interest journalism, and this is a really good sign.
Okay. There are a couple of factors. I wanted to go through each one that a court would look at in terms of the behaviour and methodology of the journalists.
Sure.
Seeking multiple sources to confirm what may be contentious. So what does that mean? That you need corroborative evidence or
Yeah, so in order for a publisher to show that their belief in the public interest was a reasonable belief, the courts will look at a whole range of factors, and one of those is not so much the quantity of sources, but really the quality and the integrity of those sources. So to be able to show that you didn't just publish something because you heard it on the grapevine, you'd heard something, you'd investigated it, and you'd sought to corroborate it through various quality sources.
Putting allegations to individuals and allowing them to respond. I noticed on the 60 Minutes program with Charlotte and Tom Steinford, they gave Dr Al Muderis some airtime and also talked to a patient of his who was happy. Is that another important factor?
Yeah, I think it's important to note that the courts won't have a checklist. You have to have done this, you have to have done this, you have to have done this. So it won't be a test of perfection.
No.
But and I don't think that giving airtime on camera is decisive one way or the other. But it would be very difficult to show that you held a reasonable belief in the public interest if you hadn't given a very good opportunity for the subject of the story to provide substantive responses to the key allegations.
So this defence hasn't been used a lot, but it has failed, maybe perhaps twice, you may correct me if
That's
I'm wrong.
correct.
But it failed in the past with a case involving the ABC, where the reporter failed to distinguish between fact and suspicion, didn't verify the allegations with other sources, and failed to get a proper response. So it's not a fail-safe, is it?
No, and that's why there were. This case is the first sign we've seen of a successful, the defence being successfully run, and it has failed a couple of times before. And so it's certainly not going to be easy. What this case clearly shows is that it's capable of being run successfully, but you must do the work. It's got to be really good quality journalism in the public interest and by quality journalists who've done a lot of thorough investigation to support their story.
So do you think it'll be an issue or arise in the forthcoming appeal of Dr Al Muderis?
It is going to be an issue in the appeal. The primary judgment by Justice Abram is detailed, comprehensive, thorough. I think it's unlikely to be overturned on public interest, or on the grounds that the public interest defence was unsuccessful. I think it's likely to be rigorously challenged, but withstand that challenge, given the comprehensive findings that were made by the primary judge.
So Charlotte was cross-examined for over 5 days, and a 6th day in a separate case, related case. Does this mean that journalists in future will face that similar challenge in the witness box?
It does, Bill. It means that if a journalist wants to plead the public interest defence, they're going to have to be prepared to give evidence and be subject to cross-examination, often very rigorous and robust cross-examination. Charlotte performed exceptionally, but not all journalists can do that. But if you've done the quality of work that someone like Charlotte had done, then hopefully journalists feel the confidence to be able to stand there confidently in court and defend their journalism.
So will all eagle eyes in the country be focused on how this goes in the appeal?
Certainly from a media law perspective we will be, because if this gets overturned on appeal, it will be a critical blow to that defence, because it will mean that there will be 3 significant cases in which the defence has failed, and I think that will set a concerning precedent for the capacity of this defence to defend journalism.
Okay, we'll watch that with interest. Thanks very much, Dean. That was terrific.
Thanks, Bill. Nice to be here.